Hey, Illinois. Today we're going to discuss township form of government and the truth of how it was stolen by the state of Illinois using unconstitutional methods and innovations of law. I'm going to start off with a bold claim and say that if the people will take the time to understand the content of this video, we can then restore Illinois. Okay, let's get to it. Today we're going to discuss township form of government, the truth of how it was stolen by the state of Illinois using unconstitutional methods and innovations of law. This presentation will be quite long, but it's necessary if we want to restore Illinois and return it to the people. Please understand this video is basically a one take. It's largely unedited with just some pauses if I need to take a break or something. So please forgive the lack of technical knowledge and ability to make it fancy and polished. We're going to focus on the content and the truth of what is written in our constitutions and in law. I would suggest that I'll make a bold claim that this video should go viral. And if the people of Illinois will take the time to slow down and learn the fundamental principles, what we're going to discover today is the root of the issues in Illinois. Now, it doesn't matter if you're a Democrat or Republican, a liberal or conservative. What matters is what is written in our constitutions and then the fundamental principles and understanding that. So if you know me, you know that most people would categorize me as a Republican and a conservative. However, if you can see what's going on in Illinois, you can begin to see that party politics is not something that's beneficial for our time, and it is a distraction from the fundamental principles of law. And Jesus said that a house divided cannot stand. Now, that's what God's word said. The principle of that remains true. And if we continue to be involved in party politics rather than the rule of law, we're going to continue to see Illinois slip away and be further removed from the control and the will of the people. So first, we have to start with biblical principles found in the Illinois Constitution. This video and information is simply a presentation of truth by right as one of the people. It's not legal advice, and I'm simply the one presenting the information. So first and foremost, I want to thank the Lord for revealing this information to us. Secondly, I want to thank the many others that assisted in gathering, teaching, and learning this information to make this presentation possible. Article 1, Section 4 of the Illinois Constitution says, all persons may speak, write, and publish freely, being responsible for the abuse of that liberty. In trials liable both civil and criminal, the truth, when published with good motives and for justifiable ends, shall be a sufficient defense. What does that remind you of? It reminds me of John 8:32, when Jesus said, and ye shall know the truth, and the truth shall make you free. This is just one of the many principles that we find in our constitutions and in law that derive directly from the Bible and the scriptural principles that the Lord gave us to apply. Section 5 of our Constitution says, the people have the right to assemble in a peaceable manner, to consult for the common good, to make known their opinions to their representatives, and to apply for redress of grievances. Isaiah 1:18 says, come now, let us reason together, says the Lord. Though your sins may be as scarlet, they shall be as white as snow. Though they be red like crimson, they shall be as wool. I want to suggest to you that we, the people of Illinois, have been derelict in our duties. We've allowed our government to get way out of hand and go much further beyond the rule of law. And it's up to the people to bring that back into the constraints of the Constitution and how things are supposed to be run. And God's word is true, and he says, let us reason together. That's assembling, and we have that right in Section 5 of our Illinois Constitution. Hosea chapter 4, verses 1 through 7. It says, "Hear the word of the Lord, ye children of Israel, for the Lord hath a controversy with the inhabitants of the land, because there is no truth, no mercy, no knowledge of God in the land." That word controversy is a law term, and we're the inhabitants of the land. We have to understand and make the connection between law and God's word. It says, "By swearing and lying," now remember, our public servants swear an oath, but then do they uphold the oath? Do they keep the oath to the Constitution? "By swearing and lying and killing and stealing and committing adultery, they break out, and blood toucheth blood. Therefore shall the land mourn, and everyone that dwelleth therein shall languish. With the beasts of the field, and with the fowls of heaven, yea, the fishes of the sea also shall be taken away. Yet let no man strive, nor reprove another, for thy people are as they that strive with the priest. Therefore shalt thou fall in the day, and the prophet also shall fall with thee in the night, and I will destroy thy mother." Now here's the key. "My people are destroyed for lack of knowledge. Because thou hast rejected knowledge, I will also reject thee, that thou shalt be no priest to me. Seeing thou hast forgotten the law of thy God, I will also forget thy children." Now, a lot of people stop short on this verse, but it's not only that we lack the knowledge, but that we also reject it. And we forget the law of God, which is our constitutions that have his principles baked into them. So you look at what they're doing right now with the Homeschool Act and with trying to provide avenues to take the children from the people. And God's word, his word is true. He says, "If we forget thy law, I will also forget thy children." There are dramatic impacts when we stray away from God's law, when we stray away from our constitutions. So we need to repent and change our ways, because in verse 7 it says, as they were increased, so they sinned against me. Therefore I will change their glory into shame." The reality is, we, the people of Illinois, have been derelict in our duties to hold our government servants accountable. Now, I don't like the idea that we have to do that, because they should be upholding the Constitution. But the fact is that they're not. And we have to learn the ways of our forefathers of how we bring them into the constraints of the Constitution. This has been going on for generations, and it's up to us to restore God's law and our constitutional principles. Illinois Constitution, Article 1, Section 23, warns us and tells us what happens if we don't frequently recur to the fundamental principles. Now, before we even read it, I want you to understand, what are the fundamental principles? First and foremost, they're the Word of God. And then it's maxims of law, and then our constitutions. It's our duty and obligation, just as Hosea 4 shows us, and the results of what happens if we don't do these things. Our children and our posterity are at risk here. Section 23 says, "A frequent recurrence to the fundamental principles of civil government is necessary to preserve the blessings of liberty. These blessings cannot endure unless the people recognize their corresponding individual obligations and responsibilities." You know, you won't find many places in a constitution where it says the people must or shall do something. Matter of fact, we're not required to do much. But if we want to maintain and preserve the blessings of liberty, then we need to take action. We need to become well-versed in our constitutions, well-versed in the maxims and principles of law and in God's word. So what are maxims of law? We'll get into that, and we'll explain that a little bit further. But before we do that, we need to cover a little bit more ground. In the United States Constitution, Article 4, Section 4, it says, "The United States shall guarantee to every state in this union a republican form of government." It's critical to understand because you have so many people talking about democracy, democracy, democracy. But we're not a democracy. We're a republican form of government. And we'll explain that a little bit later on in this video to help you see how it's important that we understand what the fundamental principles of a republican form of government are. The 10th Amendment of the United States Constitution says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So you have to ask yourself for a minute, how does this work? And if you watch Rick Green and David Barton's video in the biblical citizenship course, they go on and explain this a little bit. And I really like the analogy they use that the power, they use a bucket analogy, and if you have the power pictured of all the people in the bucket, and then they take some of the power and put it into the bucket for the United States, the federal government, and that's covered by our federal Constitution. But then there's this whole bucket of power left. In that bucket, then you put some into for the state. So the people get granted some power to the states. But then both of those buckets, we put lids on them. And they can't just go in and access more power or use power that they don't have. But then it says this peculiar part at the end of Amendment 10 where it says, or to the people. And then what do the people have? They have this bucket of power that's still full of all kinds of power. But my question then becomes, how do we assert that power? How do we wield that power? Certainly there has to be more than just being able to vote and hope these people follow the Constitution. And if you start to learn the fundamental principles of law, you start to understand that there's ways that we can assert power, whether they're in legal ways or using the power of a township, which is really going to be the focus of what we're talking about today. But we always have to look at some definitions so that we make sure we understand everything correctly. And in Black's Law Dictionary, the 4th edition, on page 824, it gives us the definition of a republican government. It's one in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people to whom those powers are specially delegated. And so here again, you have to look at this and say, wait a minute, what's going on here? Because I don't feel very sovereign. I don't feel like I have a whole lot of power. But as we go through this video, I think you're going to see how our power's been hidden from us. And, a lot of people get scared of this word sovereignty and being sovereign. Well, there is a movement out there called the sovereign citizens, and that's not what I'm advocating for. There are a couple elements of truth into what some of those people believe and think and do, but then it goes off into an area of anarchy, like where there isn't a rule of law. Their whole thing is to just remove government altogether. And that's not what we're talking about here, and that's not what I'm advocating for. What we're talking about is a republican form of government. But it says this phrase in here where it says, where the sovereignty are vested in the people and are exercised by the people either directly or through representatives. Now, there's two parts to understand here is, first of all, how do we assert power directly? There certainly has to be more than just the ballot box and how we do that. And then also understanding that the power granted to government and the representatives is specially delegated. That doesn't mean that they have carte blanche authority over everything, only in certain areas and only according to the strict text of the Constitution. Now, we just read the definition of republican government. You saw it with your own eyes. Before we discuss local government and county structure, let's hear from Supreme Court Justice Neil Gorsuch to confirm that what I've explained is not mere theory, it's not fantasy, it's the truth. Supreme Court justices are regarded as among America's wisest and most astute minds. Their words carry immense weight with attorneys and with legal scholars and with the American public. Here, Justice Gorsuch, in multiple interviews and different settings, affirms that you, as an individual, one of the people, and collectively as the people, are sovereign.
We all have inalienable rights. We are all equal. And the powers of government derive their just authority from the people themselves, that we are sovereign. It is we the people. Those are the first three words of the Constitution. And you are the sovereign in this country. And you look at the promises in the Declaration, and they're so profound, right? We are all created equal. We have inalienable rights. They don't come from government. They belong to each of us. And government derives its just powers from the consent of the governed. We are the sovereign in this country, we the people.
So we have to start to understand our county government structures in Illinois. In Illinois, there are three types of county government. There's a commission form, an executive form, and a county under township. This is notably different from a county with some townships. In this analysis, we'll focus on Kendall County, although it's relevant to other counties that maintain the county under township structure. Each county must be examined to determine how and when its form changed and whether this change adhered to constitutional guidelines. So don't get lost on these things. We're going to very briefly cover commission and executive, but we're going to focus heavily on county under township. Now think of what that means. That means it's a county under township. I should do that opposite. The county is there and it is underneath the townships. The townships are the ones in authority. But is that what we see today? It's not. We're going to go through the constitutional transition of local governments, specifically in Illinois, specifically related to Kendall County, and then later on we're going to relate it directly to Little Rock Township. But we have to go through some history first because we always have to build off of the foundation and trace the source of power for everything. In 1818, Illinois got its first constitution and got statehood. In 1841, Kendall County was formed. In 1848, we got our second constitution. In 1849, Little Rock Township was formed. In 1870, we got our third constitution. And in 1970, 100 years later, we got our fourth and our current constitution. And then in 1971, Kendall County changed the form of government. So we're going to have to investigate that and look a little bit. So going back through this timeline, we're going to quickly catch up to speed and see what has happened. So in 1818, Illinois got its statehood. And remember, we're guaranteed a Republican form of government per Article 4, Section 4 of our U.S. Constitution. And in a Republican form of government, when you have a new state coming in, the new states have equal footing as the original states. So broadly speaking, every new state may exercise all the powers of government which belong to the original 13 states. We're not lesser than the original 13 colonies. They're brought in on equal footing. And that's evidenced in the preamble of the Illinois Constitution, our original one, in 1818, because we always need to trace the source of power. And note that the people created the state. It says the people of the Illinois Territory having right of admission into the general government as a member of the Union, consistent with the Constitution of the United States, the Ordinance of Congress of 1787, and the law of Congress approved April 18th, 1818, entitled, An Act to Enable the People of Illinois Territory to form a constitution and state government for the admission of such state into the Union on equal footing with the original states and for other purposes, in order to establish justice, promote welfare, and secure blessings of liberty to themselves and their posterity, do by their representatives in convention ordain and establish the following constitution or form of government. So understand what's taking place there. It's the people that have gathered with representatives to ordain and establish. The source of power of Illinois comes from the people coming together and authorizing the state to be created. This isn't government granting power. This is the people granting power. So understanding a little bit of Illinois history, it actually dates back to 1778. Virginia actually claimed Illinois as a county. That was news to me. I didn't know that, but our source actually comes from Virginia. So Virginia was one of the original 13, and they claimed Illinois as a county. And in 1784, Virginia ceded the county of Illinois to the federal government. They found that it was hard to govern from afar, and so they turned Illinois over to the federal government. In 1787, the federal government included Illinois in the Northwest Ordinance of Territory that included Ohio, Indiana, Michigan, and Wisconsin. And then in 1809, Illinois became its own separate territory. And then that leads us to what we just read. In 1818, Illinois was a territory, but then became a full-fledged state on equal footing and guaranteed a Republican form of government. So our roots actually come out of Virginia. Now you'll find in the 1818 Illinois Constitution counties. Now there were 15 counties that existed prior to the creation of the state. It was Madison, St. Clair, Bond, Washington, Monroe, Randolph, Jackson, Johnson, Franklin, Union, Pope, Gallatin, White, Edwards, and Crawford. And in these counties, they were ran by 3 commissioners. So prior to the 1848 Constitution coming about, there was a discussion about whether how the counties and townships related and what is the better form of government. So there were no townships in Illinois originally. And we followed this Virginia model of government where they had a county with 3 commissioners. And that same style continued when we created the 1818 Constitution and all the way up through 1848. So Kendall County was formed by the Illinois State Legislature, not by a direct vote of the people. So in February of 1841, the Illinois General Assembly passed a bill to create Kendall County, which it carved out portions of LaSalle and Kane counties. This action followed a petition circulated in the fall of 1840 by settlers in the area. They wanted the establishment of a new county due to the inconvenience of traveling the long distances to their respective county seats in Ottawa for LaSalle County and Geneva for Kane County. The petition was signed by 109 settlers, and they requested the formation of a new county eventually consisting of 9 townships. The legislative process culminated on February 19th, 1841, when a bill was approved and signed into law officially establishing Kendall County. While the initial push came from local residents via the petition, the actual creation of the county was a decision made by the state legislature, consistent with how most of the counties in Illinois were formed during that period. After its establishment, the first elections for county officials were held on April 5th, 1841. This marked the beginning of local governance, but it was separate from the act of formation itself. So Kendall County's creation was a legislative act, not a direct popular vote. So the source of power was that this was a legislative act of the General Assembly. The people are still the source of power, but that runs through the General Assembly. And this is key for our understanding because this puts the county under the state and under the General Assembly. So in 1818, that's what Kendall County was created under the 1818 Constitution. And it says in Schedule Section 4 of that Constitution that there shall be elected in each county 3 county commissioners for the purpose of transacting all county business, whose time of service, power, and duties shall be regulated and defined by law. So first of all, we have to understand that in constitutions, the word shall means that it's a definitive mandate. It must happen. It's impervious to discretion. And 1818 didn't have any provisions for townships. There were only counties. So these were statutory powers and duties for transacting business. The General Assembly at the state had legislative authority over the counties. This is key to understand. We followed the Virginia model at that time, which meant that the counties were created by the state legislature. So then in 1848, Illinois got its second constitution, and there was a discussion of townships that preceded this. County by township was introduced and adopted by the people and enumerated. This discussion was because the model of the northeastern states, they were very prosperous with the township model of local self-governance. But I do want to highlight that this preceded the Civil War. And so Illinois was, remember, created out of a Virginia model that followed kind of the southern states' form of local government. But then they started to recognize that the northern states were having prosperity, freedom, liberty, no slavery, things like that. And Illinois started to have this discussion because people started moving into the area from these northern states. And so they started to discuss this township form of government. So what happened is in 1848, we got a new constitution. And it says in section 6 of that, Article 7, section 6, it says the General Assembly shall provide by a general law for a township organization under which any county may organize, whenever a majority of the voters of such county at any general election shall so determine, and whenever any county shall adopt a township organization, so much of this constitution as provides for the management of the fiscal concerns of the said county by the county court may be dispensed with, and the affairs of said county may be transacted in such manner as the General Assembly may provide. So what happened here is the people of Illinois decided that they wanted to have this township organization offered to each county. This wasn't a statewide mandate that each county had to. It was each county with the introduction of this new constitution, each county would get to make a decision. The people of that county would decide how they wanted their county to function. So what this provision does is it orders the General Assembly to make this a statewide offering, but it also keeps the General Assembly from the power to dictate to the counties and townships on how to transact their business or how they're going to do their local form. It opens up the door for the people to decide how they want their government to be. So then after that, in 1849, at the very next general election, Kendall County formed into 9 townships, and Little Rock Township was one of them. And this changed the county board from these 3 commissioners that we used to have to then 9 board of supervisors. So what happened was the people voted, they divided the county into 9 townships, and each of those townships elects a township supervisor. And those township supervisors get together and they form your county board, or what was called a county board of supervisors. So after the 1848 Constitution was approved by the people and enacted, in 1849 at the very next general election, Kendall County, along with many others, decided that they wanted this county under township form of government. And here we have the documentation from that. This is that November 6, 1849, and some other years for other counties, but very early on, 46 counties adopted this township organization or county under township model. Later on, other counties transitioned to the county under township form in the same manner. It was always by a vote of the people. And an interesting thing to keep in mind with this is the way that they did it wasn't just 50 plus 1% of the people that voted. If they would get the total number of voters in a county, and if somebody didn't go and vote, they would count that against or not to change the form. So the people had to be active in really doing this, because you had to overcome, if somebody didn't go and vote, it was counted against this and not for it. So the people really came out and showed up and changed their local form of government and how it was going to work. Again, it's important to note that just because a county has townships doesn't mean it's a county under townships, under township organization. There's a difference between the two. Presumably, a county or somebody with a local area within a county could create a township, but that wouldn't necessarily change the local government of a county. So you could conceivably still have a county that had a township, but it wasn't a county under township organization. That would be like a county with a township. So this transition was recognizing that decentralized, fragmented government was better and more prosperous than centralized government. And again, we always need to trace the source of power. Did the state or the legislature create the township, or did the people? And the answer is the people did. So when you had Kendall County created, it was the legislature that created that. But when you had the townships created, the people created that. And then the county now falls under the people in their townships and not under the state legislature. You're going to have to stop and think about that one for a bit, because we are way far off base from what our local government's supposed to be. This is all about centralized power versus decentralized and fragmented power. And both can be Republican in form, but which form brings you directly to the people, where the people can have direct impact? And that's what the people during that era were seeing, was that the township, county under township organization was a better fit for local governance directly by the people. In 1940, there's an old township book that I have that lists out counties under township here. And so you can see that the list begins to grow a bit for how many counties there are under township. It started off with 46 originally, and then by 1940, I think it was 85 of them. I think that list has 85. You'd have to pause it and count to see for sure. And then even on the current Township of Illinois organization website, that's the Township Associations, it denotes in here that there are currently 85, today 85 of the 102 counties operate under the township form of government. And 1,426 townships serve more than 8 million citizens. Now, it notes in here the annual town meeting is still an important function. We're going to get into that a little bit later, but just so you understand as we're talking, at the annual town meeting is where the people run the meeting. And we still have those in place, and those still take place today, the second Tuesday of April, all of the townships gather in their own township and the people run the meeting. So understand that townships get their power from the people, whereas counties were formed by state legislature. So if you have a county that's under commission form, that's running through the state legislature. But if you have a county under township form, that's running through the people. Big difference. So then what happened is from 1849 until 1870, Illinois operated on the 1849 or 1848 Constitution, and the townships were formed and counties under townships were formed. But also note what happened during this time. That was pre-Civil War, and then 1870, known as the Reconstruction era, was when Illinois got its third constitution. And in that, the people recognized that when they created the township form of government, they still left the General Assembly, the state legislature, with a lot of power and control over the townships. And so after the Civil War, they wanted to even more strictly identify that the townships were sovereign and independent from legislature. And remember, this is after the Civil War. So they enumerated prohibitions of the General Assembly in relation to townships and to counties. But you have to understand the difference between a county under township versus a county with a commission form, because it's all about the source of power and where it flows. All the power always comes from the people, but how do we more closely assert our power? Is it easier to assert power within your county by having to run through the state legislature? Or is it easier to assert power in your county by going through your townships, which a township, county under township, that places that county beneath the township? So I hope you can begin to see that really matters. So this was a response during the Reconstruction era after the Civil War. So remember that the people had seen what happens to a state that has centralized government, like the southern states. There's a lot of freedoms and liberties that were at stake, and they realized that we needed to be more like the northern states. And this enumerated prohibitions of the General Assembly in relation to counties and townships. So in this article, section 22, it's the legislative article of the Illinois 1870 Constitution. And it says, the General Assembly shall not pass local or special laws in any of the following enumerated cases. That is to say, 4. And it goes on and lists a bunch of things. Now you can pause this and read all of these things because it's quite interesting, but we're going to focus on, for the purpose of this video, on just 2 aspects of this, and maybe mention a third because I want to wet your whistle for what we can do as the people to hold our Illinois government accountable according to the express text of the Constitution. One of those things is regulating county and township affairs. Now, that's a very short sentence, but what does it mean? And if you look in the 1828 Webster's Dictionary, which is pertinent because what the words meant at the time they were written is important to understand. And the word regulate in there, it means to subject to rules or restrictions, or to adjust by rule, method, or established mode. Now remember, statutes from legislature are rules. So they directly prohibited the General Assembly from making rules concerning county and township affairs. So the next word we have to look at is the word affairs. And if you look in the 1828 Webster's Dictionary, it means business of any kind. And it also says it's a word of very indefinite and undefinable undefinable signification. So it's very ambiguous, very broad. It means, hey, they can't mess with any of our local business. And it also says specifically, part of the definition, it's the public concerns of executing laws and administering government. So you can see here that the townships really put a limitation on what the General Assembly could do locally. Now we're going to skip down here to where it says providing for election of members of the Board of Supervisors in townships, incorporated towns, or cities. So they were directly prohibited from providing for the election of members of the Board of Supervisors in townships. Now, in townships, incorporated towns, or cities. So understand what that means, because in a county under township, you don't have a separately elected county board or board of commissioners. You have a county board of supervisors, which is made up from each supervisor that is elected in each township. They come together and form that board. Now, the word provide in Webster's 1828 dictionary, it means to produce beforehand, to prepare, or to make ready for future use. So the General Assembly was directly prohibited from preparing a means for or to make ready for use this Board of Supervisors, which would be your county board. One other thing here, just to mention that little snippet that I mentioned before, there's the summoning of and impaneling of grand or petit juries. Understand that locally, there's a lot of power that we have lost access to because we have not understood what a county under township form of government is. Now, in 1870 Constitution, Article 10 about the counties, Section 5, says the General Assembly shall provide by general law for township organization under which any county may organize, whether a majority of the legal voters of such county voting in any general election shall so determine. And whenever any county shall adopt township organization, so much of this constitution as provides for the management of fiscal concerns of the said county by the Board of County Commissioners may be dispensed with, and the affairs of said county may be transacted in such manner as the General Assembly may provide. So what that means is if the people decided on a county under township organization that dispensed with, or it got rid of the county board of commissioners, and it left all that. So that was given over to the board of supervisors. And it says, and in any county that shall have adopted a township organization, the question of continuing the same may be submitted to a vote of the electors of such county at a general election in the manner that is now or may be provided by law. And if a majority of all the votes cast upon that question shall be against township, then such organization shall cease in said county, and all laws in force in relation to counties not having township organization shall immediately take effect. So what is that saying? That's saying, first of all, that's telling us some things. There's some tells in there. There were laws that the General Assembly can write for counties that are not under township organization. The county commissioners, if you have that county commission form, the county commissioners are dispensed with. This means they were waived or set aside because you brought in the county board of supervisors. If a township organization is voted out, the commissioners come back in and all laws in force immediately take effect. I hope you can see how the state does have authority in counties with commissions, but it's very, very limited if the county is under township form. So then we continue on for 100 years until the 1970 Constitution comes into play. Now, this is the moment it all changed using wordplay and lawfare for Illinois. There's a case called Reynolds v. Sims from 1964 with this idea of one-man vote and dealing with apportionment for state legislatures, but not for local government. Now, we have to understand what has taken place during this time frame, because there was these innovations of law that started happening from like the 1950s on. They started changing words of what they meant in the law dictionaries. If you look at the Black's Law 5th edition and just read the preface of it, they openly tell you that they're modernizing law. Well, you can't modernize law when our constitutions are based off the fundamental principles. So we're going to go over some of these things, not because we have to, but because I know that that's going to be the common things when somebody puts in a Google search or tries to figure out why or what, they're going to see these things. But I want to point out why these things don't matter. And the first thing is Reynolds versus Sims. First of all, it was out of Alabama and it was relating to state legislature, not local government. As the result of this, this created a national phenomenon that began to happen where it was the centralization of government in many states. Some states, like Illinois, rushed out and got a new constitution. And other states didn't do that, but they started doing several amendments to their founding documents. We need to understand that this is well after innovations of law had started, moving us away from the fundamental principles and maxims of law. These things were all done by attorneys. In Luke 11:52, Jesus warns us. He says, "Woe unto you lawyers, for you have hidden the key of knowledge." The Illinois Constitution from 1970 was presided over by a man named Samuel Whitwer, a prominent Chicago attorney. He notably influenced and steered this convention, producing this quote unquote modernized constitution. Where our older constitutions were easier to understand, this new one's filled with legalese, innovations of law. It's a lawyer's dream because it's very hard to understand. But they couldn't get rid of the fundamental principles. They simply had to try to hide them and then begin to operate, assuming the people's complacency and ignorance and rejection of knowledge would get them to create this centralized government we see today. Sadly, we have to admit they succeeded for now. But it's all being exposed, and it's going to be up to the people to take back what is theirs. And this can all be done peacefully and lawfully. The law is on our side, and our constitutions are on our side. But we have to take the time to learn what they mean. So the Illinois 1970 Constitution has this provision for townships. In Article 7 of Local Government, Section 5, it specifically says, "The General Assembly shall provide by law for the formation of townships in any county when approved by countywide referendum." Understand that this is the formation of townships, not done by the General Assembly. All they do is provide the means or the statute on how this is done lawfully and legally by the people, but it has to be approved by a countywide referendum. Townships may be consolidated or merged, or one or more townships may be dissolved or divided when approved by referendum in each township affected. All townships in a county may be dissolved when approved by a referendum in the total area in which township officers are elected. Understand, every single time you're going to change the form of government, that has to be done by the people. In a Republican form of government, government cannot change itself. Government cannot alter itself. It's only the people that can alter, reform, or abolish their form of government. So this also doesn't necessarily mean that a county begins functioning under township form. It just means that there can be the creation or dissolution of a township within a county or in the entire county. Now let's look at this part. Same section of local government under section 3. Part A, a county board shall be elected in each county. The number of members of the county board shall be fixed by ordinance in each county within limitations provided by law. So what this is saying is that there must be a county board in each county, but it doesn't tell you what type of board. That's determined by the county, whether they want to be a county under township, then that board would be a board of supervisors, one supervisor from each township. If it was a commission form, it'd be separately elected people to that board, and if it was the executive form, it would be a little bit different. But notice that it's the county board shall be fixed by ordinance. Now, ordinance means it's a local law, and an ordinance is a local law, county or township created. A statute is what's created by the General Assembly. The General Assembly doesn't create statute. The General Assembly creates statute. The county board and townships, they create ordinances. In Part B, it says the General Assembly by law shall provide methods available to counties for the election of a county board members. No county other than Cook County may change its method of voting board members except as approved by a county-wide referendum. Notice what's happening here. The General Assembly is granted power to make methods available to all counties for the election of county board members. In Illinois, there's many different types of Republican forms of government for local government. Some states have different county structures. In Illinois, there's 3. It's a county commission style, a county board of supervisors under township, and an executive style. And so what this does is this grants power to the General Assembly and tells them, hey, you have to make a process for the people to form their county boards, but notice what it says here, the second sentence, no county. Just leave out the other than Cook County. Okay, Cook County doesn't apply to this, but Kendall County and all the other counties do. No county may change its method of electing board members except as approved by a county-wide referendum. Because when you change your method on how you elect your board members for the county, that determines what type of county form of local government that you have. That's a huge deal, and that has to be done by the people because it's only the people that can alter, restore, or abolish their government. So the Constitution clearly says that it must be by a referendum to change the method of electing board members. Part C applies to only Cook County, which isn't the topic of this video, so we're going to skip that. Now we're going to go to a little-known part of the Illinois Constitution called the transition schedule. I guarantee you nobody has taught you about this, and you have never heard of it. I know I hadn't, and I know we hadn't, and we've been studying it. And in this transition schedule, it has its own preamble. And it says the following schedule provisions shall remain. So remember that word shall is important. It's impervious to discretion. It shall remain part of this Constitution until their terms have been executed. Once each year, the Attorney General shall review the following provisions and certify to the Secretary of State which, if any, have been executed. Any provisions so certified shall thereafter be removed from the schedule and no longer published as part of this Constitution. So how this is supposed to work in 1971, when this went into enactment, the Attorney General each year has to see if the terms and conditions have been met so they can remove these transitions. Well, you can see that in Section 1, whatever that was, has been removed. Section 3, that came to being, so that was removed. Section 7 and 10, the same thing. But look what still remains here. Section 5 on local government and Section 9 of general transition. So the Attorney General is supposed to review this each year, and he does. I'm not saying that he's not doing his job. I'm saying that these things are still very much alive and well within our Constitution because they haven't been removed. So we're going to look at Section 5 and Section 9 to see what it says. Remember, this is in the transition schedule. This is Section 5 of the transition schedule. And it says in Part A, the number of members of a county board in a county which, as of the effective date of this Constitution, elects 3 members at large, may be changed only as approved by countywide referendum. So first of all, we again see that you can only change it by a referendum. And we also see that this is only pertaining to a county that elects 3 members. So it's talking about that county commission form of government with 3 members. That dates all the way back to the 1818 Constitution. But the first question I have is, does this even apply to Kendall County? The answer is no, because in 1970, we were still operating with our county board of supervisors because we're supposed to be a county under township form of government. So we didn't have the 3 commissioners style. We had a county under township, which had the 9 members of the board of supervisors. But even still, it can only be changed by countywide referendum. It says if the number of members of such a county board is changed by countywide referendum, the provisions of Section 3A of Article 7 relating to the number of members of a county board shall govern thereafter. So again, that doesn't apply to Kendall County. It only applies to county boards that had the 3 members. Section B only applies to Cook County, so we're going to skip that for now. And Section C, this is very interesting because it's speaking of townships. So in the same section, it says, townships in existence on the effective date of this Constitution are continued until consolidated, merged, divided, or dissolved in accordance with Section 5 of Article 7. Now, we already showed Section 5 of Article 7, which said that anything that had to be done by referendum. And townships in existence are continued. So this continues townships, and by default, it continues the County Board of Supervisors. Nothing changes for Kendall County. And then we get to Section 9 of the transition schedule. And it says, the rights and duties of all public bodies shall remain as if this Constitution had not been adopted, with the exception of such changes as are contained in this Constitution. All laws, ordinances, regulations, and rules of court not contrary to or inconsistent with the provisions of this Constitution shall remain in force. So pause and think about that. The township is a public body. So is Kendall County. The county is a public body. It says that they shall remain as if this Constitution had not been adopted. All laws, ordinances, regulations, rules of court not contrary to or inconsistent with shall remain in force. It says, until they shall expire by their own limitation or shall be altered or repealed pursuant to this Constitution. Well, what is pursuant to this Constitution? We have already gone over and emphasized the only way to change the form of local government is by referendum. So in order to change from a county under township, there has to be a vote from the people. In order to create or dissolve a township, there has to be a vote from the people. It's always by the people. So anything that is not done by referendum is not pursuant to this Constitution, nor is it pursuant to the previous one. So what would what would, if it says that with the provisions of this Constitution shall remain in force until they shall expire by their own limitation or be altered or repealed. So if you'll notice that the 1870 Constitution was never fully abolished, it's continued. There are things from the 1870 Constitution that are continued. One of those things being township and county under township form of government. There is an expressly a requirement to have referendums when changing, altering, or reforming the counties and their townships. And if you go down and read a little bit further, it says all officers filling any office by election or appointment shall continue to exercise the duties thereof until their offices shall have been abolished or their successors selected and qualified in accordance with this Constitution or laws enacted pursuant thereto. So this does not get rid of a county board of supervisors. As a matter of fact, it continues them because everything has to be done in pursuance to the Constitution, and the officers filling an office, any office by election, would be your county board of supervisors. They're continued, they get to exercise the duties thereof unless they've been abolished. There is no expressed abolition of county under township. There is no expressed abolition of a county board of supervisors. And so we should be continuing the county board of supervisors. This should be something that has continued to roll throughout time, but it hasn't, and we're going to explain how and why. Okay, so before we go any further, we're going to have to discuss a couple of things about what the fundamental principles of law are. And you'll notice on this slide, the title has changed, and now it says government altered itself. In 1971, the Kendall County Board changed the county's type and style of government. And we'll go over that in a minute. But first, I want to go over what is a maxim of law. In the Black's Law Dictionary, second edition, it says a maxim is an established principle or proposition, a principle of law universally admitted as being a correct statement of law or as agreeable to natural reason. Later on, it's talking about Koch, and he defines a maxim to be a conclusion of reason. And he says in another place, a maxim is a proposition to be of all men confessed and granted without proof, argument, or discourse. So a maxim of law is a fundamental principle. It's a principle of law that's universally admitted. Everyone agrees that it's true. One of those things that are true is that in a Republican form of government, government can't alter itself because otherwise you don't have a Republican form of government. So it's only that the people can alter government. There's many more maxims that establish everything in our constitution. Our constitutions are actually based upon the maxims of law, and many of the maxims of law come directly from principles in Scripture. So understand that we haven't known about maxims of law, nor are attorneys these days. They aren't taught maxims of law. Everything in these innovated things of law that they're doing within our court system and our government are innovations of law. They are not based off of the maxims of law, but our constitutions are. And that's how we've gotten away from looking at our constitutions and seeing what they say and then coming up with and accepting an excuse of why we're not doing it. One basic example of that is the Illinois Constitution says that our elections are supposed to be on one day. Now, are elections on one day? No, they've started doing elections over multiple days. So that's a very fundamental thing that says our election is supposed to be on one day. The only latitude that we gave our General Assembly is they can choose a different day. It's supposed to be the first Tuesday of November. but they have been granted authority to change the day on when our elections can be held. But that's the only latitude we gave them. They're strictly within those bounds. And now we have elections that aren't even taking place on the day of, but they're going, they're starting weeks ahead of time. So that's because we've lost the fundamental principles of law. We haven't understood maxims. But as it applies to this, we're going to go to and look at what happened in 1971. So in 1971, Kendall County changed their form of county government. Now, I wasn't even alive at this time. And what I'm suggesting is not that these people even did this in Kendall County on purpose. They were ignorant of the law, but they rejected the knowledge. We had gone through a period from 1870 to 1970 where things took place and the people started drifting away from the fundamental principles of law, drifting away from God's word and how things were supposed to be done. And because of that, ignorance happens and we reject knowledge, and then there's takeover that happens. And that's not how it's supposed to go. So on July 1st in 1971, the Kendall County Board of Supervisors unanimously voted to reapportionment without a constitutional action by the people, i.e. a referendum. Remember, it's only the people that have the right to alter, reform, or abolish their government. Now, this date is important to understand because while it says that our Constitution is the 1970 Constitution, that's when it was approved, but it didn't go into effect until July 1st of 1971. So, of course, the people voted in the, November of 1970, but then it doesn't actually go into operation until July 1st of 1971. Now, we're going to look at what was dug up here. We found the minutes from the meeting where this happened. And I want you to pay attention to the language here because this is the minutes from the Kendall County Board of Supervisors adjourned regular June meeting. So they had their regular meeting in June, and then on July 1st, they had this special meeting. And notice the title of it. It's the Kendall County Board of Supervisors. So even up to July 1st of 1971, we're very clearly still operating with a Board of Supervisors, which means we're a county under township organization. And it says that the County Board of Supervisors met at the courthouse in the city of Yorkville, July 1st, 1971 at 1 p.m. pursuant to the adjourned regular June meeting on June 28th, 1971, with supervisors. Notice they don't call them county board members. They're called supervisors. Nichols, Christian, Wormley, Shoger, Mann, Sleezer, Zeter, Whitfield, Stewart, and Hacker present. Supervisor Naden absent. In the absence of Supervisor Naden, chairman of the board, Supervisor Myron Wormley, chairman of the legislative committee, acted as chairman pro tem. Resolution for apportionment plan. Whereas, pursuant to Section 831, Chapter 34, Illinois Revised Statutes, the county of Kendall is required through its county board to develop an apportionment plan and specify the number of districts and number of county board members to be elected from each district, and also to determine the method of determining the chairman of the county board and the method of compensation for the members of the county board. And whereas the county board for the county of Kendall has determined the number of members to be elected and the number of districts to be formed within the county, and I can't read what that one says, within the county, and the method of determining the chairman of the county board, and the method of compensation for members of the county board. Now, therefore, it is resolved as follows. The county board of County of Kendall shall consist of 10 members. So remember, they had 9, so they changed the quantity. The members of the county board shall be elected from the county by districts. So then they created districts, not the townships. The said districts of the county shall be enumerated and defined as follows, with 5 members to be elected from each district. District 1, Bristol, Little Rock, Fox, Big Grove. District 2, Oswego, Kendall, Naosay, Lisbon, and Seward. And this was adopted on the first day of July, 1971. So understand what took place here, because we have just read what our Constitution says. It says that these things can only happen by referendum. They can't happen by statute. And we also saw that the townships were continued from the 1870 Constitution. And we saw that in the 1870 Constitution that there was prohibitions from the General Assembly writing statute for the providing of the members of Board of Supervisors. So there's many things that are taking place here, but one of them is, first of all, the Kendall County Board did not change by referendum. They changed by the supervisors meeting. So government changed itself. That in and of itself is unconstitutional on its face. The second issue is that they're doing it pursuant to Chapter 34 of the Illinois Revised Statutes. Well, that statute was written before July 1st of 1971. It had to be, because this is requiring them to change by July 1st of 1971. That means that that General Assembly was operating under the 1870 Constitution, which expressly prohibited them from involving themselves in providing for the election of the Board of Supervisors. So there are 2 constitutional disqualifications here for this action that was taken place, that took place. No referendum, and understand that there has been affidavits and notices sent to the county board to ask them, provide the proof that this was done according to the Constitution. Nobody has responded. Nobody's responding because they can't, because this was done clearly by this statute, or I'm sorry, by pursuant to the statute and at a county board meeting. So you can't just do that. The government can't just change itself. So we're going to go into a couple more law and maxims here just to understand and settle the matter that this can't happen this way. Miranda v. Arizona is a case from 1966, and it says, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Now, just so you understand, a referendum is a right of the people. Now, it's a new term. It's an innovation of law. It's made up because in a referendum, it only has to be 50%, 50 plus 1% of the people that voted. But tradition and history tells us that the way that you can change government is not that way, but it's when the majority of the community votes on it. So going back to what I said before, when we formed a county under township form of government, we did it where the people voted, and it had to be 50 plus 1% of the people in the county that were of voting age, or registered voters. It was not done by referendum. Now, that being said, we're not going to argue about the referendum thing because it is in our Constitution, but just understand that in order to change form of government, it has to always come from the people. The next one is Norton v. Shelby County from the 1800s. And this is out of Tennessee, but this is what it says directly in this case. And we're going to go over this case in a little bit because it's very fundamental to the exact thing that we're talking about. It says an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Boy, that's a mouthful. But we just showed where the county board changed how they were elected and the number of people that were elected. They did it following an unconstitutional statute or an unconstitutional act, and they did it without a vote by the people, and the General Assembly was directly prohibited from even involving themselves in that. So an unconstitutional act is not law. That means whatever they did there, it's not law. It confers no rights. It imposes no duties. It affords no protection. What does that mean? You see, we have granted immunity to our public servants when they follow the Constitution. But they don't have immunity when they don't follow. They have protection when they follow the Constitution. If they're following the Constitution, you can't sue them. You can't come after them for a violation of rights because they're following the Constitution. But when they do things that don't follow the Constitution, they are no longer granted immunity. And this is seen in a recent Trump v. U.S. Case where they're talking about private acts and things like that. But then notice the second part here. It says it creates no office. Well, what we used to have was the office of a county board of supervisors. What we now have are county board members separately elected from districts and not a county board of supervisors. So they're sitting in offices that weren't ever lawfully created. In legal contemplation, it's as inoperative as though it had never been passed. Boy, that's a big deal because that means that everything that's been taking place since July 1st of 1971 is not done according to the frame and form of law. Now, there's a maxim that says time cannot render valid an act void in its origin. So the act that took place in 1971 on July 1st, just because it's been a long time, does not mean that it's valid. Just because the people haven't spoken up because we haven't understood these things doesn't mean that it's valid. It doesn't mean we can't revert back to what we're supposed to have. And there's another maxim of law. It says void in part is void in toto. That means that if what they did was even partially void, which it was, then the whole thing is void. Now we've had there's a lot of things take place, whether it comes, all of these different county agencies and organizations and county structure of stuff that have taken place since then. And that all pushes to centralization of government rather than having the fragmented form that we're supposed to have. Because if we have that fragmented form, then the people can be directly involved in what takes place. And we don't have to necessarily go through representatives to get things to happen. So kind of bookending this transition from the 1870 to the 1970 Constitution, there's things that took place. And in 1886, there was this Norton v. Shelby County case. And in 1964, there was this Reynolds versus Sims case. So we're going to go through these just very briefly, just so we get a flavor and an understanding for what's taking place. First of all, in 1964 was Reynolds v. Sims. Now this deals with the apportionment for state legislature, not local government. So understand that right out of the gate. It deals with state legislature, not local government. And also what was taking place, this is out of Alabama. And also, what some of the claims were in this case were that it was racial discrimination. So there was the courts got involved and made a decision and started discussing this thing. Now, we'll read a couple parts of this just so we understand it. It was Reynolds v. Sims, 1964, and it's charging that malapportionment, that means bad apportionment, of the Alabama legislature deprived them and others similarly situated of rights under the Equal Protection Clause of the 14th Amendment and the Alabama Constitution. So first of all is dealing with rights and of the Equal Protection Clause. And because they were electing legislators at large over the entire state. So there wasn't a very good apportionment from having your vote count for much. It says in that case, we decided that an apportionment, speaking of a previous case, we decided that an apportionment of congressional seats, which contracts the value of some votes and expands that of others, is unconstitutional, since the federal Constitution intends that when qualified voters elect members of Congress, each vote shall be given as much weight as any other vote. We conclude that the constitutional prescription for election of members of the House of Representatives by the people, construed in its historical context, means that as nearly as practicable, one man's vote in a congressional election is to be worth as much as another's. So understand that this is where the one man vote came from, that everybody will talk about concerning this thing of why they did what they did in 1970. But understand what they're saying. First of all, that was for state legislature, not local government. And secondly, as you're going to see here in a little bit, the people can directly take action in a township form of government and directly hold their county board of supervisors amenable through a township meeting. How much more direct can you get than that, where your vote actually means something, and it's not just the vote in the ballot box, but it's even for taking action on something. One more thing I want to point out here, and this is just a side note in case this topic ever gets into a legal battle. The state might really want to use caution if they're going to lean on this ruling, because it clearly says down at the bottom here that other rights, even the most basic, are illusory if the right to vote is undermined. Well, our Constitution says that our elections are supposed to be on one day. So that's our part of our rights, and other rights, even the most basic, are figments of imagination if the right to vote is undermined. So if I was an attorney that was going to try and argue against what we're saying today, I'd use a lot of caution about using this case, because it's just going to open a can of worms for other stuff. So something else that came up recently, and just to see you so you can see how this whole quote unquote case law thing that's kind of a hoax works. There is no such thing as case law. It's the law of a case. And the law of the case can be different. So you can't just take one Supreme Court ruling and then justify changing the entire frame and form of local government because of it. But that's exactly what happened around that 1970 period. But here recently, on May 23rd of 2024, there was another Supreme Court case, South Carolina NAACP. It was Alexander, president of the South Carolina Senate, versus South Carolina State Conference of the NAACP. This was in May 23rd, 2024. And it says the Constitution entrusts state legislatures with the primary responsibility for drawing congressional districts and legislative redistricting. It is an inescapably political enterprise. So again, this one has to do with state legislature, not local government. And they say that this case, the way that they ruled on it was because this was a political party-based argument, not racial discrimination. So this one didn't involve rights, where the other one involved rights. The point I'm making is that first, both of these cases have to do with federal and state apportionment, not local. And secondly, SCOTUS recognizes that they have no input if it's a legislative issue, which means it must be pursuant to the Constitution, not some lawyer's interpretation of some case. Lastly, in this case, they point back to New York versus Bruin case, which speaks about the text, history, and tradition. It also points to using contemporary definitions or what the words meant at the time they were written, not new made up definitions for what these words mean. How much more direct to a one-man vote can you get than literally being able to act as a legislator in your township and have your township supervisor be your representation on a county board of supervisors? We'll cover that more in a little bit. So now we're going to look at Norton v. Shelby County from 1886. Note the time frame. This is after the 1870 Illinois Constitution. This is out of the state of Tennessee. But when you look into back into history a little bit, before these innovations of law started taking place, you can see how it was dealt with. So this case is out of Tennessee. It's basically a mirror image of what happened in Illinois, specifically in Kendall County, among others. And what it says is this court follows the decisions of the highest court of a state in construing the Constitution and laws of the state unless they conflict with or impair the efficacy of some principle of the federal Constitution or of a federal statute or a rule of commercial or general law. The decisions of state courts on questions relating to the existence of its subordinate tribunals and the eligibility and election or appointment of their officers. Following the decisions of the highest court of Tennessee and other cases, this court holds that the Board of Commissioners of Shelby County, organized under the Act, which would be a statute, of March 9th, 1867. It had no lawful existence, and it was unauthorized. It was an unauthorized and illegal body, and its members were usurpers of the functions and powers of the justices of peace of the county, that in their action in holding a county court was void, and that their acts in subscribing to the stock of blah, 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 and it goes on there. If you read down further, an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation, as inoperative as though it had never been passed. So if you're going to read any case, this is the case to read because it's the exact same thing. Now, it's not apples to apples as far as how their local county operated, but that doesn't matter. The principle remains is that they changed the way their county functioned under a statute that had no lawful existence and was unauthorized. It was an illegal body. It created an illegal body, and the members, it says, were usurpers of functions and powers. So what does that make our current county board? Now, I'm not saying that they knew these things or they understand them, but they've been presented with this stuff. And it's important because I actually, personally, I don't have a beef with the Kendall County Board. They've been relatively good. But the problem is it's the flow of power and how can or how do we get our state in check if we have an illegal or improperly formed board? Because these people think they have to follow every statute and dictate that comes out of Springfield. But the reality is there's actually prohibitions that are in place. And when things don't follow the form and process of law, you can lawfully say no. You can lawfully ignore some of these things. And this centralized government that we have that has been created for us, but not by us, is unconstitutional. It confers no rights, it imposes no duties, it affords no protection, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. This is a big deal. This is a real big deal.